Good afternoon, everyone. My name is Rugengi Christian, a law student at Kabarak University, and I currently serve as the chairperson for the Center for Legal Aid and Clinical Legal Education, CLACLE in brackets, at Kabarak Law School. On behalf of the Center for Legal Aid and Clinical Legal Education, I warmly welcome you to our inaugural webinar titled From Judgment to Justice, Implementation of the Ogiek Case Kenya. We are truly delighted to have participants joining from across and beyond Kenya, representing academia, civil society, national institutions, regional organizations. And thank you all for taking time to be part of this important conversation. So today's webinar is jointly organized by CLACLE in collaboration with NANHRI, the Network of African Human Rights Institution, the Network of African National Human Rights Institution. Through this collaboration, we hope to create a platform that connects academic voices, practitioners, human rights institutions in advancing the implementation of African human rights decisions. So, when it comes to the objective of this webinar, we seek to explore the implementation of the Ogiek case, one of the most significant decisions of the African Court on Human and People's Rights. And we are here to reflect on the progress that have been made since the judgment was delivered, the ongoing challenges in implementing the case, and some of the strategies in achieving the full compliance and justice for the Ogiek community. That being said, at the end of this webinar, we hope that everyone will deepen the understanding of the Ogiek case and its broader significance when it comes to the legal significance, to assess the current state implementation of the judgment and reparations, to examine the national and regional implementation efforts, and finally, it's just to provide a platform for dialogue between legal practitioners, human rights advocates, and law students. That being said, allow me to welcome our first panelist, who is Ekisa Ian. Ian Ekisa is the legal aid coordinator of the Kabarak Law School Legal Clinic, and also one of the legal clinician students at CLACLE. So, Mr. Ekisa, the floor is yours. You'll have 15 minutes, so just take your time and take us through the overview. We'll be setting the scene of the presentation, give the summary of the Ogiek case, the facts, the remedy granted, and yeah, so the floor is yours, Ekisa.
Yeah, thank you so much, Rugenge, my chairperson. Once again, my name is Yanda Kanikisa, as he has introduced, and I'm the legal aid coordinator. And so I then proceed to give us this, discuss the history of the Ogiek, who are the Ogiek, and how they ended up to being evicted, and how the case ended up at African Court on Human and People's Rights. So we have the brief facts or historical background of who the Ogiek are in Kenya. And this as well has been discussed by the avid readers webinar a few months ago, while Kabarak University Law School was celebrating the implementation of the Constitution of Katiba at 10. And I'll borrow from the history that was provided by one of the panelists in the webinar, and who was as well involved in this case. So the Ogiek community, the Ogiek is an indigenous community in Kenya, and they are primarily hunters and gatherers, and they resided in the Kenya's highlands and Mau forest. So they also practiced beekeeping, hunting and gathering, and their culture was based was filed in the forest ecosystem. So here we have the Mau Forest Complex in context. So basically, history shows that the Ogiek community has ties with the Kalenjin community. But again, we have the history on the colonial concept. So we had colonial forest policies that progressively restricted access of the Ogiek community to the Mau forest, and this now generates, or this is now the beginning of the problems for the Ogiek community in Kenya. So post-independence, the government then, through the government forest management, I would say led to the eviction of the Ogiek community. And also, the Ogiek community as well faced struggles for recognition and identity crisis in Kenya. And so with that brief background of the Ogiek community and their struggles, I will then proceed to giving us the summary and overview of the case at the African Court on Human and People's Rights. So I will say, as I've earlier said, the gay community, being a hunters and gatherers group in Kenya, and for decades, having lived in the Mau Forest complex, and the government having evicted them from the forest, and the government evicted them, claiming that that was due to environmental conservation and public interest, and for public interest matters. So two bodies are filed. Two bodies in two Kenyan organizations approached the African Commission, alleging this violation of rights. And the two bodies were the Center for Minority Rights Development and Minority Rights Group International, which acted on behalf of the Ogiek. And so the African Commission on Human and People's Rights filed the case on behalf of the Ogiek at the African Court, alleging the violation of rights such as rights in the African Charter. For example, the right to property under Article 14, the right to non-discrimination under Article 2, the right to religion under Article 8, the right to culture under Article 17 of the Charter, the right to freely dispose of natural resources, and the right to development under Article 22. So in 2017, the court found Kenya responsible for violating the rights that I've mentioned. And in 2022, there was the African Court issued judgment on specifically dealing with reparations and how the Kenyan state should compensate and restore the Ogiek community. And so in the case, there are at least three main issues in the case. And the first issue was whether the Ogiek community was entitled to pecuniary or monetary reparations, and as well non-pecuniary or moral and restitutionary reparations. And so another issue, the second issue was how now to determine and quantify the amount of compensation pursuant to the violations of these rights. And the third main issue was whether the Ogiek were entitled to restitution of ancestral lands and legal recognition of ownership. And so the African Commission on Human and People's Rights, on behalf of the Ogiek community, made claims and arguments. And the first, among the claims and arguments on behalf of the Ogiek was that the applicant claimed material and pecuniary loss from evictions, i.e. loss of homes, livestock, and access to land and forest resources. So the applicant sought in compensation material harm at amount of 92,500,000 USD for moral harm. And there was this argument on where the respondent, the Kenyan state, argued that the reparations were claimed in USD currency, yet the issue was an African problem, and it was filed in a regional court, which is the African court. And so they claim that these amounts of money were claimed at USD and they were based on lack of facts and they were fanciful. And again, so the applicants again, which is on behalf of the Ogiek community, so they claimed or requested restitution, which is the return of the Ogiek ancestral lands through one delimitation, demarcation, and communal titling within 1 year after the judgment of reparation had been made by the court. And again, the applicants argued that there are existing laws in Kenya, i.e. Community Land Act of 2016 and Forest Conservation and Management Act of 2016, which could facilitate restitution. So, however, the respondent state, which is the Kenyan state as well, had their arguments in the case. And of course, they opposed the monetary claims as being speculative and unsupported.
Sorry to interrupt. You only have
Yes.
5 minutes to go, so try to wind up. You have 5 minutes to go.
Yeah, I'm winding up. Yeah. Okay, thank you. So I'll give the respondent's argument and the court's finding. So I was saying, of course, the Kenyan state opposed the monetary claims as being speculative and unsupported by evidence. So they denied that the Ogiek owned the Mau forest, and they argue that the court had only granted them access and use rights and not ownership rights. So they also maintain that demarcation and titling would set a dangerous precedent for forest conservation and other communities. And the Kenyan state suggested that non-repetition guarantees and rehabilitation measures were more appropriate remedies than compensating the Ogiek community. So, despite all, the court analyzed and gave determinations and judgment on the same. And so the court recognized difficulty of precise quantification, given the nature of the Ogiek's lifestyle and passage of time. And so the court held that the Kenyan state actions directly caused material loss, which violated Article 14 to 22 of the African Charter. And so the court exercised equitable discretion, awarding 57,850,000 in Kenyan shillings for material harm. So, and the court emphasized fairness over the mathematical precision or accuracy. So, as well, the court reaffirmed that moral prejudice, including loss of culture of the Ogiek, religion and identity, could be compensated without strict proof. And so the court found that Ogiek suffered significant distress and discrimination under Articles 2, 18, 17, and 22 of the Charter, and awarded 100 million Kenyan shillings in moral damages. And the court stressed that the violations affected the community's existence and dignity. And so, as well, the court on restitution ordered that restitution was the primary form of reparation, and directed the Kenyan state to delimit, demarcate, and title the Ogieka ancestral land. So, so there was now the holding hand of the African court. As I've said, there was 57,850,000 in Kenyan shillings for material prejudice and 100,000 for moral prejudice and restitution. However, there were other prayers by the applicant, such as public apology, but the court say that the judgment is enough rather than apologies. Would be better than public apologies. And as well, there was the argument by the applicant to order the state to erect a monument to recognize the violation of the rights, but the court as well dismissed that prayer. So those are just the overview of the case. And so I would say the most significant part of the whole judgment is how the court used equity to, underscore flexibility of human rights remedies, especially where strict proof was difficult. And as well, how the court reaffirmed land ownership and restitution, claiming that right to property does not only mean access, but would mean ownership. Yeah, I think that's what I can say on the overview and background and historical background of the Ogiek and the whole case. Yeah, thank you. Back to you, Rugenga.
Yeah, thank you very much, Ekisa, for the clear and insightful overview of the Ogiek case. So we now turn to our second panelist. Our second panelist is Mr. Cyrus Mawewu, the Deputy Director in charge of Redress and Legal Service and Chair of the Indigenous Peoples Committee at the Kenya National Commission on Human Rights. So he will discuss the national implementation effort and the role of the National Commission on Human Rights in the Ogiek case, the challenges faced in ensuring full compliance of the case. Mr. Cyrus, the floor is yours. Yeah, thank you. And you'll also have 15 minutes. So yeah, asante sana.
Thank you very much, Christian and Kabarak University for organizing this and for inviting us to share in this discussion. The Ogiek decision is very significant for a number of reasons. One, it's the first decision by the African Court on Human and People's Rights on the rights of indigenous people. And it's very progressive in the way the court approached the discourse on the rights of indigenous people. It sets a very good precedent in terms of reparations for rights and even on the merits. Unfortunately, not much has been done since 2017, when the first decision on merits was was rendered, and then the subsequent decision on reparations. So I will just be highlighting the efforts so far, the outcome, if any, and as you've requested, I'll also try as much as possible to highlight some of the challenges. I'm trying my best to share my screen. I hope you and others can see it. So I'll basically start from 2017. There was a very big celebration with the Ogiek, and the commission joined because we believe that, or we believed and we still believe that this is a very good decision, and its implementation will pave the way for other indigenous communities in Kenya and would, to a very large extent, resolve the land questions around recognition and what happens in the event of violation of all these rights. It's generally accepted everywhere that for every violation, there must be a remedy. And for sure, the court appreciated that, having confirmed different violations in the judgment on merits. The reparations judgment was very clear on what needs to be done. And part of what we did, before I just highlight the general picture, the commission supports and complements in the implementation of these decisions of regional mechanisms. So the Ogiek case is like the third case that has been rendered by these regional mechanisms against the Republic of Kenya. Many of you may remember the Inaugural case, a similar case that touched on the rights of indigenous people, touching on the Inaugural community in Baringo, and that was filed at the African Commission on Human and People's Rights. Then there were the cases by the Nubian community, and then finally the case by the Ogiek community. So for today, I'll only limit my focus on the Ogiek case. Immediately the decision on merits was given, the court had ordered the government of the Republic of Kenya to take steps to comply and file a report within 180 days. So the Kenyan government, through the then Cabinet Secretary for the Ministry of Environment and Forestry, appointed a task force. The state had the opportunity to engage the communities, other stakeholders, with a view to coming up with solutions. There was a subsequent task force. Unfortunately, the reports of the task force have not been made public. So there have been other implementation efforts. The commission has been supporting the community, especially through close partnership with the community members, as well as the Ogiek People's Development Program. In 2023, the commission did a fact-finding investigation mission that revealed a number of violations related especially to the land question, evictions from the land in Mau, and the commission filed a public interest litigation before the Environment and Land Court in Nakuru. The commission also shared on its website the judgment of the African Court on Human and People's Rights, and actually issued a press statement welcoming that judgment and calling for its implementation, because we believe the judgment alone is not enough and communities go to court because there are violations, and it's only through implementation that they will be able to enjoy the fruits of the judgment or the justice that they were seeking before these mechanisms. We've also continued to intensify advocacy through a number of platforms, and not only by ourselves, but in conjunction with, amongst others, the community itself, the community organization, basically the Ogiek People's Development Program, a number of civil society organizations. We've also used our reporting obligation, both regionally and nationally, to call for the implementation of this decision. And we've also had a number of engagements with different actors, both state and non-state, to come up with an implementation matrix. Our advocacy has been both local, regional, and international, and part of what we've been advocating for is one, legislation that basically operationalizes the rights of indigenous people. We keep talking about free, prior, and informed consent. In practice, how would that look like? How would we operationalize the rights of indigenous people? Questions around recognition, and more significant for us because of the experience that these communities have always been subjected to. A better approach to conservation. So we've advocated for human rights-based approach to conservation, and we believe that there's a need to shift and look at it and look at the human rights concerns in conservation. We've also used our State of Human Rights reports to call for implementation of this decision. There, if you can see from the screen, just basically some of those efforts, a demonstration of those efforts where we had written to the state, and the state actually responded on the question of recognition of the Ogiek, and the Nubian as ethnic communities in Kenya. We've also continued to do documentation, fact-finding, as and when there are allegations and reports of violations. Just like I'd mentioned, it's the investigations and fact-finding missions that have disclosed the need to file the public interest litigation that we supported the community in doing. Last year, we had a public inquiry looking at indigenous people broadly, and now they are affected by businesses. And part of what arose was the implementation of that decision of the African Court on Human and People's Rights. We've continued to conduct and enhance awareness on both local and regional redress mechanisms, as well as the rights. But as you requested, I will proceed to briefly address some of the challenges that we continue to face as an institution, as communities, and as a country. And for me, one of the key challenges is the question of recognition. This was an issue before the court. The court had actually issued express orders on recognition of the Ogiek as an ethnic community in Kenya. I've lifted a quote there: if you are invisible in everyday life, your needs will not be thought of, let alone addressed in a crisis situation. So you can imagine, unless we get to that level of proper recognition, then we'll continue grappling with some of these questions, even the question of implementation of these decisions. The other challenge is around the question of land tenure, because that was one of the key questions that the Ogiek as a community had raised and posed for the court to answer, and the panelist who's just spoken before me has ably addressed that, what the court found in terms of possession and actual ownership. And there was an order for demarcation and titling of that land, and that has not happened. Now, while land insecurity is a big challenge, especially for indigenous people, it's because of the interconnectedness between indigenous people and their lands. They need those lands to exercise certain other rights. So the land becomes a right in and of itself, and a facilitative right or a mechanism for them to enjoy, among others, the rights to their culture, the rights to their religion, and also their identity as an indigenous community. And I've given just a photo of the Ogiek and the recent evictions in Mau. I just highlight this because I mentioned our approach, or some of the approaches to conservation, the fortress approach to conservation, where the narrative seems to be that you need to get everyone out of the conservation areas for you to pursue conservation. And that has not really worked very well. In fact, there is history, which is very well documented, and research that indicates that conservation pursued in partnership and in close collaboration with indigenous communities is actually the most effective. And that is part of what we've been advocating for: inclusion and participation of indigenous people in the conservation efforts that the state on a day-to-day basis keeps to pursue. There are many other questions, especially policy. We don't have a policy on recognition. I am happy that there's a window of opportunity at the moment, because I've seen a call for submission of inputs, memoranda, or just broadly submissions on a draft national policy on ethnic minorities and marginalized communities. And this could present a window of opportunity for us to engage as national human rights institutions, as different actors, as communities, as academia, as well as the communities themselves, in raising the concerns and what needs to be put into place to ensure that there's at least an objective framework for recognition of these communities, because it just happens. And shockingly, is even in cases where the communities have gone to court and the courts have issued those decisions, that has not happened. As a commission, as I wind up, we've also been very vocal on the rule of law and the need to comply with court decisions broadly, not just limited to the decisions of the regional human rights mechanisms, but also our local decisions, because we still have cases where there has not been compliance. Again, if you refer to the Ogiek experience, there were cases even before the case that went to the African Court on Human and People's Rights. In those cases, if you look at, for instance, Joseph Letuya, there were orders that there's a need to identify the land and also come up with a register of who the Ogieks are, and that has not happened yet. So as a commission, we remain committed and we remain a key partner to the communities in supporting their quest for remedies, and I'll be happy to take questions at an opportune moment. Thank you, and back to you, Christian.
Thank you very much, Mr. Cyrus, and thank you for the brief summary of the role of the Commission in this case. We really appreciate your presence here. So we are going to turn to our final panelist, who is Mr. Folusho. Mr. Folusho is the Program Officer at the Network of African National Human Rights Institutions, NANHRI. Will provide a regional and institutional perspective exploring how national human rights institutions can monitor and support the implementation of African human rights decisions, and how NANHRI work with state and civil society to advance these goals. So, Mr. Folusho, the floor is yours.
Hi everyone. Can you hear me? Can you hear me again?
We can hear you.
Okay. Thank you very much. And let me say a big congratulations to the team and for putting together this webinar. It's a pleasure to be a part of this very important discussion on implementation of decisions of African human rights bodies, and particularly starting with the Ogiek decision of the African Court. So my name is Folusho Adigalu. I work for the Network of African National Human Rights Institution, which is an umbrella body for 46 African National Human Rights Institutions based in Nairobi. And it's actually interesting listening to Mr. Cyrus, who works for the Kenya National Commission on Human Rights, because they are also, the commission is part of the network, and I think we actually sit in the same building. So in trying to also stick to time, I would speak briefly, I think just to the problem of implementation generally, just highlighting the fact that the issue of lack of implementation of decisions issued by African human rights bodies, which in this case, the African Commission on Human and People's Rights, the African Court on Human and People's Rights, and the African Committee of Experts on the Right and Welfare of the Child is a widespread problem. And I think from the previous presentation, we've heard that so little has been done so far with regards to the remedies issued by the African Court in the Ogiek case. So this is actually a very big challenge for all of the African human rights bodies. And there's been quite a lot of discussion and effort around how the implementation of decision of African human rights bodies can be improved. From the different studies carried out by the bodies themselves, including the African Court and the African Committee of Experts on the Right and Welfare of the Child, there is a very low rate of implementation of their decision, and I think for the court it was about 7%. And till date, the only two cases that have been in a sense, fully implemented by the African Court is the decision against Burkina Faso, and it's really around compensation. So the broad challenge of implementation, of course, lies in the fact that there is generally lack of political will by African states to give effect to the commitments that they've made under the respective international human rights treaties that allow for these respective bodies to issue decision. So that's the biggest challenge to implementation across the continent, and also even beyond the African human rights system, even at the United Nations human rights system, there is also this challenge to implementation. So it's also not limited only to the African continent. Then the other challenge to implementation include lack of institutional and coordinated approach to follow up on implementation by states. And in this regard, there's now been some development around the establishment of national mechanism for reporting and follow-up by different states. And the idea is that this national mechanism for reporting and follow-up can help the different states to track the different orders, and including recommendations even from the state reporting procedure that have been issued by monitoring bodies. And then it's a bit easier for states to then, look at these recommendations holistically and come up with like some sort of like plan on how to implement the decision. Of course, this is all still down to the issue of political will, which means that the state is in essence willing to comply with the decision. And now we're looking at some of the technical aspects that can be of challenge to the state. And this second part is where I think a discussion would just dovetail into, because this is where now we can see the role of different actors, and in this regards, National Human Rights Institution coming in with regards to supporting the implementation. The reason why I've given this background is because I just want us to be very clear on the fact that the issue of implementation and the responsibility lies with the states, because they are the primary duty bearer with regards to their international commitment. So the other efforts that other stakeholders are bringing in ideally are tailored towards supporting the states to be able to implement this decision. So for National Human Rights Institution, of course, for National Human Rights Institution, they have a unique status in which they are, in the sense of the fact that they are established by the states, but they are expected to operate independently of the states. And one of their core tasks is to monitor and advise the states, of course, depending on their establishing law, on how to comply with their international human rights commitments. And in this regards, we can see that it becomes a natural fit for National Human Rights Institution to, encourage and advocate for their respective states to implement the decisions issued by African human rights bodies, because this is one of the core mandates of National Human Rights Institutions. And for the Network of African National Human Rights Institution, in terms of some of the institutional innovation that we try to also bring in place to support the National Human Rights Institution to be able to perform this task of advocating for the implementation of decisions by their states. It's a recent engagement that we've been having with our National Human Rights Institution, which is tailored towards the development of National Human Rights Institution Implementation Unit. And this is because when it comes to the role that is expected of National Human Rights Institution for supporting implementation, which revolves now around advocacy and not so I think in two cases, at the national level and at the regional level. So they can advocate, of course, and encourage the states to comply with the decision, but also at the international level and regional level, in our case, in the case of our discussion, they can document, information with regards to the status of implementation. And this can be shared with the human rights bodies, and they can also engage through submission of either complementary report to whatever report that has been submitted by the states in the event that the states have submitted reports. And they can also participate, for example, in implementation hearing if the body is conducting an implementation hearing in with respect to the case. So the idea of National Human Rights Institution Implementation Unit is the fact that for National Human Rights Institution, we thought that it would be useful that there is a specific unit in each National Human Rights Institution, depending on the capacity of the National Human Rights Institution, that primarily has the role of following up on implementation of decisions of African human rights bodies, and decisions here and recommendations from concluding observations are used together. And this was a discussion during the NANHRI African Union Commission Policy Dialogue in May in Addis Ababa. And there we had the participation of over 25 national human rights institutions represented by the various heads of the institution, and also the different stakeholders, including the representative of the African Court, the committee, and the commission. So the discussion revolved around issues of implementation, challenges to implementation, and then the idea of the NHRI implementation unit was actually discussed, and it was endorsed by the different leaders of this National Human Rights Institution. So in August of this year as well, building on that discussion and on that commitment, we actually had the first capacity building for about 14 national human rights institutions, including the Kenya National Commission on Human Rights, where we discuss, how this can happen in practice, because, the idea of theory and practice, they are two separate things. So each institution discussing what they see as visible with regards to how they could come up with an implementation unit. And the agreement was that there should be like a formal designation through the leadership of the National Human Rights Institution. And the unit should have like register and databases to track like decisions and compliance progress. And there should be like a tripartite engagement for the NHRI implementation unit, which would include collaborating with government, of course, at the national level, and also interfacing with the African Union human rights bodies, and also with civil society organizations and victims. So like a tripartite form of engagement. And in this regard, we have actually seen some very positive steps taken by the Kenya National Commission on Human Rights in their recent submission to the UPR, where they had actually called on the government of Kenya to implement the decisions issued by both the African Commission and the African Committee of Experts on the Right and Welfare of the Child, and the African Court, regarding Kenya. And this was actually done by the representative of Kenya in the capacity building workshop that we did in August. So in a nutshell, I'm trying to stay to time. I think I can take further questions. The role of National Human Rights Institution when it comes to implementation of decision is to engage with the government at the national level, calling on them to implement the decision, but also most importantly, to engage as well with the human rights bodies that have issued the decision by providing information, because the information provided by National Human Rights Institution are of very useful value to the African human rights bodies, because National Human Rights Institution are state establishment, and that is a bit different from reports submitted by civil society organizations, for example, which the state can also challenge on the ground of lack of legitimacy, let's say, for the civil society organization. I think I would stop here and I'll hand over back to you, Ruge. Thanks.
Thank you very much, dear Felusho, and thank you to all our panelists for their mind-provoking and insightful presentation. So I think now we are moving into our interactive session. It's now the Q&A session, and I invite our audience to share their reflections. If they have questions, they can raise the questions. Just feel free to post your question in the chat or raise your hand, and I will allow you to speak. Yeah, so dear audience, you can ask the questions for our panelists in case you have any before I ask my own questions. So yeah, I welcome you all to feel free to raise your hands. Let me check in the chat. Oh, there's a question by Nabintu Wanchiko. So good afternoon. I'm called Nabintu Wanchiko. I have two questions for our panelists. The court ruled that future eviction could be justified on the ground of public interest and necessity. Don't you think that its failure to harmonize Ogiek interests with those of the state, given its tendency to regard state interests as superior to those of indigenous people, opened the door for future dispossession, the very injustice the court was meant to address? That's the first question. So it addressed, seems like, to all the panelists. The second one is, what assurance of justice exists for the Ogiek people when the courts leave the implementation of its order vague and unenforceable by allowing the state to decide whether to grant royalty, leasehold, or other form of restitution, choices that I can't read this, repatriate into yet another tool of control. So for the second question, I don't know whether Nabintu can rewrite it because the final part is not clear enough. But for the first question, let me reread. The court ruled that future eviction could be justified on ground of public interest and necessity. Don't you think that its failure to harmonize the Ogiek interests with those of the state, given its failure to harmonize, Ogiek interests with those of the states, given its tendency to regard state interests as superior to those of the indigenous people, open the door for future dispossession, the very injustice the court was meant to address? That's the first question. So I'll open yeah, she has corrected the second one. For the second one, I hope you're taking notes. What insurance of justice exists for the Ogiek people when the court leaves the implementation of its order vague and unenforceable by allowing the state to decide whether to grant royalty, leasehold, or other form of restitution, choices that ration into yet another tool of control? Yep, so those are the two questions. I give the floor to the panelists. I don't know, we'll go fast, but we can start with Mr. Cyrus, then for Lucio, then Ikisa will share also the reflection on the question. In the meantime, we are waiting for other questions, so feel free to ask your question as well, dear audience.
Thank you, Nabintu, hope I got that right, for those questions. I'll start with the first question. I'm not too sure the court failed to harmonize the interests of both the community as well as the state, because the court went into a very elaborate analysis of what the state was raising in response to the concerns raised by the community on each of the violations before it pronounced itself. And one of the things that the court did was to actually reject that climate change or the need for conservation could justify the evictions in the manner that the Ogiek were evicted from their ancestral lands in Mau. The court was also clear on the question of ancestral land rights and made an express order for identification of the land, titling, identification of that land, demarcation and titling. So I don't know if that would be, in a way, considered a bit vague and open to different interpretations. But I think there was some sense of clarity on what the court ordered should be done. I'm also aware that there are pending proceedings, because I know there was a status conference hearing, basically for the state to report on the measures that it's taken in terms of implementation of the decision. And maybe that would provide an opportunity to clarify. But I believe in my mind that it's not for lack of clarity on what needs to be done that the decision has not been implemented. If I pick just one simple example, one of the orders was to publish that decision in a medium of national circulation and also a government website. What does it take to publish a decision? There was an order for recognition. What will it take to recognize the community? So I really am not too sure that it's a question of vagueness or the orders being overbroad. I believe there was clarity and certainty on what ought to be done, even in terms of the payments that were to be effected and the manner in which that compensation was to be handled through a community development fund. In terms of assurances of justice, I think it's a question of compliance, because again, it's a rule of law question. A decision has been passed, it's delivered, it's binding. There's no room for appeal. If you look at the rules, the protocol establishing the court, such a decision rendered by the court unanimously is not open to any appeal. So it's purely a question of compliance. If it's not clear, I don't know if it's open to the parties to go and ask the court, but my mind remains clear that what ought to be done is clearly communicated in the two decisions, especially the reparations judgment. I think I can stop at that and hand the floor back to you and fellow panelists. Thank you.
Yeah, thank you very much, Mr. Cyrus. So I don't know, Mr. Felusho, if you have anything about the questions. Yeah, you can feel free to answer any of them. It seems like we have lost Mr. Felusho. So Ekisa, I don't know, is there any reflection you want to share as well before we move to the second question?
Yeah. Okay. I then build my answer from the previous panelist, and when I read the case, I saw that the court acknowledged that environmental conservation and protection of natural resources could constitute legitimate public interest under Article 14 of the African Charter. But again, it held that states have a duty to protect the environment. But the court emphasized that public interest is not an absolute license. And for that to happen, it must be lawful, it must be necessary, proportionate, and non-discriminatory. So the court relied on the principle of proportionality and applied three tests, which is legitimacy, necessity, and proportionality. And so the court held that the aim of environmental protection was legitimate, yes, but the measures that were taken by the state were not necessary to achieve environmental protection. And so as well, I would say, just like the previous speaker has said, the court did its best in trying to protect the Ogiek and balancing public interest, which is the claim by the state. So, and again, the court concluded that public interest as a defense had not been established under Article 14. And as well as I've said, the necessity requirement had not been met. And it again even made comparative analysis with other cases and international laws. And Yeah, so as well, I don't think that the court never harmonized, just like the previous speaker has said. Yeah.
Yeah, thank you very much, Ikisa. So let me raise the second question. So the second question is by Jimmy Wambua. So Jimmy Wambua is a third-year law student, and his question is on the scope of the free, prior, and informed consent. So he would like to know what constitutes effective consultation, and when does the state's duty to consult transform into a duty to obtain free, prior, and informed consent under the African Charter, because the court considered they had not done so, or an evidence record of lack of conversation by the Ogiek, or sorry, they consider they have not done so, or an evidence record of lack of conversation by the Ogiek, because these were one of the counter arguments of the state. So Jimmy would like to know about what constitutes an effective consultation, and when does the state's duty to consult transform into a duty to obtain free, prior, and informed consent under the African Charter, because the court considered they had not done so, I mean the state, or an evidence record of lack of conversation by the Ogiek, because these were some of the counter-arguments by the state. So yeah, the floor is yours, Mr. Cyrus and Ekisa. You can feel free to answer this second question. Yeah, and then I'll just ask two questions as well before we close our webinar today.
Let me attempt. One, there's no mathematical precision in terms of what qualifies as effective public participation, but I'll just speak to the quality of what would, in my view, amount to effective public participation. The first thing for me is the diversity of the people participating and the extent of their participation and the information that they have to support their participation. It's not enough to just mobilize people. There are communities and there are other dynamics that one has to be alive to. If you're mobilizing for a public event, you need to look at gender dynamics, age dynamics, to bring on board the youth, the elderly, women, persons with disabilities, minorities, especially because if you just leave it open, in some areas and some communities, the marginalized and ethnic minorities may never really get a chance to participate. The other aspect that I'd highlighted is the quality of participation. And for one to participate effectively, it basically needs that there should be some reasonable sharing of information on what is being discussed, so that people don't just attend a meeting without an idea of what is being discussed. I'll just pick an example from the budget making processes. It's a complex, it's a technical process, but sometimes you just find people being mobilized to attend a meeting. The drafts may not even have been shared, especially when it's quite advanced and they are supposed to review or input. So it makes it a bit hard for people to participate when there isn't meaningful sharing of information. Finally, on the question of FPIC, it's a well-established principle, especially when you're dealing with the rights of indigenous people. And the court was very emphatic on free, prior, and informed consent. And it takes me back to what I've just discussed. What makes it free? What makes it informed? If there is no sharing of information, it must be based on something for them to consent to anything happening, especially on the lands and territories that they occupy. But it's well established. I hope moving forward as a country, when time comes for legislation to be done or policy framework, we can look critically and analyze how best we can operationalize FPIC in Kenya. Kenya has not ratified the United Nations Declaration on the Rights of Indigenous People, which is equally very clear on free, prior, and informed consent. But generally, on participation, and this will be my final take on this, public participation has been elevated to a national value and principle of governance under Article 10 of our Constitution, which is enforceable even through the judicial mechanisms. So it is no longer tokenism in terms of participation, but it's a binding obligation on anyone who is performing any functions under the Constitution, whether policy, whether legislative or administrative. I'll stop at that and cede the floor to you. Back to you, Christian.
Yeah, thank you very much, Mr. Cyrus. So I don't know whether Ikisa had any other reflection on the question you'd like to share, or we should move to the next question.
Yeah, okay. Maybe just to highlight on the parts that asked what would free, prior, and informed consent would mean, and maybe I will relate that to its effects in the case. So, just like the previous speaker said, free would mean that the consent will be given voluntary and without coercion or manipulation. So, and when we reflect to this case, we see that the Ogiek were coerced through eviction notices. And prior will mean that consultation must occur before any decision is made against a party. But when we look at its implication in this case is that there was no advance consultation to the Ogiek community, and as well the court noted that. And informed would mean that the Ogiek will be given full and clear information on proposed measures, which as well never happened because the Ogiek were not told or informed of the reasons or the plans or even the consequences of the actions that was taken by the state. And yeah, finally, consent now would mean the general approval or acceptance, and as well reflecting on the case, we'll see that the state proceeded without consent. Yeah, thank you.
Yeah, thank you very much. A question to Ian. You have provided an excellent overview of the Ogiek case and its legal significance. From your perspective as a student clinician, how can law student, and university legal aid clinic like CLACLE contribute meaningfully to ensuring that such landmark judgments move beyond theory and translate into real justice for the affected community? So I don't know. What are your thoughts on that, Ikisa?
Yeah, okay. Thank you so much, Rugenge, for that question. And I'll answer it from a student perspective and as well a leader in the Center for Legal Aid and Clinical Legal Education, CLACLE here. And I think the first answer I will give to the question is holding such webinars in collaboration with other institutions that intend to see the implementation of court decisions. Because talking about these things will mean that we can create solutions and make follow-up reports on the implementation of these cases. And this will be tied to the theme of this webinar being from judgment to justice. So essentially, ensuring that the judgment by the court does not only remain on paper, but seeing it being implemented by state, and how can CLACLE do this? And I think Folusio has mentioned this. We could do this by drafting implementation reports and periodic reports and shadow reports or policy briefs on these cases and share them with the African court and share them with legislative bodies or even civil society organizations that we can partner with. And this can only be done when we have MOUs with different institutions like the Kenya National Human Rights Commission. We have NANHRI here. We can have MOUs, draft MOUs, and have them so that we can partner in as well things like field visit. It is important as well to just visit the field and conduct legal aid trainings, legal aid awareness like we've done before, so that we can then explain these rights to community members and even translate the orders of the court to them and as well facilitate, for example, make them understand the FPIC principles that we've discussed here. We might discuss here, but members of the community, most of them will not really understand what this is. We can then do and translate these principles, these rights, in a manner that they understand. And this will promote community engagement, and as well this will promote collaboration and partnerships with organizations. Yeah, thank you.
Thank you very much, Ekisa. So, Mr. Cyrus, I think you still have some question here from people. They're not satisfied with the FPIC. This Victor Angima who asked his question come as follow. In Kenya, FPIC or matter relating to administration of community land is to be handled by the Community Land Management Committee or the Community Assembly. This is found in the Kenyan's Community Land Act. In countries with no such legislation, do elders suffice as representative, or what is the threshold for representatives? That's the question by Victor. I don't know, should I repeat the question or you got it well?
I'm not very sure I got the question very well.
Yeah, so question is, you would like to know, like in countries with no such legislation, I assume, as the Community Land Act, do elders, like the old people in the community, suffice, or are they enough as representative, or what is the threshold for representatives? Because he started the question like in Kenya, FPIC or matter relating to the administration of community land is to be handled by the Community Land Management Committee or the Community Assembly. This is found in the Kenya Community Land Act. In countries if no
Very
such,
well.
yeah. Okay, thank you.
Thank you. So allow me to first weigh in on the previous question. I agree with the previous speaker, but one other thing that students and law clinics can also do is to support in research. These things keep evolving. The questions that are placed before these human rights mechanisms, both regionally and internationally, keep evolving, and so is the nature of human rights. Everyone can benefit from a lot of research, including even in the generation and input into general comments that would widen and make more clearer the interpretation of the scope of these rights. They can also support in the development of implementation frameworks to guide how the process could be. Moving to the question, the instant question, one, if we embrace participation and FPIC as a guiding principle, whether or not the law provides for it, then it should be given effect. Consultations do not necessarily have to be through the elders. But one of the things that is well accepted internationally and regionally, even in Africa, is that you can consult indigenous people through their own structures. Some of the communities are very well organized and they have leadership that can be consulted on their behalf. But it is also expected that that leadership at community level would share the same information with the community so that as and when they give their consent, it is very well informed. So look at it both ways, through their well-organized structures and broadly with the communities at large. Nothing stops, for instance, a government institution going to the people at the grassroots level and holding the equivalent of public barazas with them to ensure that they properly understand what the issue is before they give their consent, and then now they can thereafter engage through their locally elected and accepted structures. Thank you, and back to you.
Yeah, thank you very much. I think you'll just have to keep there because there's another question by George Njogu, who is a Fofia law student, and his question will be, is there any need to balance between the scientific aspects of conservation and the law? And if so, is the law really the best remedy for such harm to the environment? Should I repeat the question?
I think I got it. If
Okay.
there's a need to balance the scientific evidence and the law, and if the law is, I'll start with the last question, and my short answer and straight answer is no. The law is never adequate. The law is not even adequate to address the things that happen in society. We have a lot of legislative lacunas, but we also have many laws that are not effected. So I don't think the law is the panacea to every thing that is going wrong in the society. I look at the law at two levels. It can be used as a tool for social engineering to basically create order in the society. But sometimes the law plays catch up. Look at what is happening in artificial intelligence and other technology related things. The society advances so much before the law catches up. So I wouldn't look at the law as the only adequate remedy to all the things that are happening within the society. But having said that, the law is equally important because it also creates some legal obligations and standards, and it provides a normative framework against which certain rights can be claimed. So I will not downplay it. I will not overemphasize its importance. On the importance of scientific evidence, it's very important to look at things scientifically, but it's equally important, especially when we are looking at conservation, to also look at empirical research. Because there's a lot of research that has been done and it's available publicly. Most of it has been published. If you look at the forests in Brazil, the forests that are occupied by indigenous communities, even in Peru, there is overwhelming evidence, empirically proven, that those forests are better conserved than the other areas. So not downplaying science, but also highlighting that we have a very clear documented history. Even in most of the forests that were traditionally occupied by indigenous people, those forests still exist to date, and maybe we've not done a proper study as a country, but it could also confirm that they may be better conserved than other areas. I wouldn't know to what extent, but it's something worth looking at. Thank you, and back to you.
Yeah, thank you very much, Mr. Cyrus. I think we are going to our last question before I invite our secretary for the vote of thanks. And my question will be mostly like, because you mentioned during your presentation, this is not the first time Kenya is being sued against a violation of community land. There was a case before even the Ogiek, the Endoria's case, if I'm not wrong. I don't want to massacre their names. Yeah, so like I would like to know, like, is there any hope when it comes to implementation of these cases? Because it feels like another case will come and we'll keep on talking about the Ogiek and maybe the new case. I'm not being pessimistic. I'm just trying to be realistic. And I would like to know from people like you who have been at the forefront of implementation at the national level and follow up with the progress. So like, do you see any change from the way things were back in 2017 and the way they look like in 2025? Or is there any way forward? Yeah, so yeah, that will be my question to you.
Thank you. Just to address your question, I know things may not look very, very good, but I wish to end on a positive note and just to inspire some hope that all is not lost. We'd rather have these judgments. We'd rather have something against which claims can be made than nothing at all. And I will borrow from the experience of the Endorois community. One of the challenges that they had was registration of the Endorois Welfare Council. That has since happened. I know there were also questions around benefit sharing, how they can benefit from the resources around Lake Bogoria. As we speak, there's an arrangement between them and the county government of Baringo, and they get, maybe not they wanted, but at least they get something. And I know they also, there have been a few efforts towards implementation, which may inspire hope. If you look at the Nubian case, for instance, it's not fully implemented, but we are not where we were in 2003. We are not when the Endorois were filing their case and when they got their decision in 2010. We are not where we were then. Again, if you look at it from a jurisprudential point of view, we litigate, for some of us who support public interest litigate, we litigate not strictly for the current case, but also for the future. So I know, for instance, the Ogiek jurisprudence has been relied upon both locally and outside Kenya to advance the rights of indigenous people. So it may not be fully implemented in the nature and in the sense in which we want it, but it continues to inspire even local jurisprudence. And maybe all those are efforts that may bear fruit one day. So all is not lost. And public interest litigation takes care of both the current and the future. Thank you.
Thank you very much. Yeah, I will also just call Ekisa to give his final reflection before I invite our HOD to do the vote of thanks. Yeah, so Ekisa, feel free to give us like what would you like people to take away from today's webinar? Yeah.
Yeah, thank you so much, Rugenge. So my closing remarks will be as well to say it is not in vain. We only have to put more efforts and move from theory to action. And just like the previous speaker said, these judgments by the courts still have impact, even if the implementation is slower. But we shouldn't give up, but do our part, as for example, as CLACLE, in partnership with other institutions to ensure that the state continues to implement, and as well to have to always have these conversations and draft reports and follow-ups to ensure that full implementation of these judgments, of these judgments for the betterment of our communities. Yeah, thank you.
Yeah, thank you very much, Ekisa. And thank you very much also to the audience for their questions. Thank you also to our panelists, Felusho, Mr. Cyrus, and Ekisa, even though Felusho, we have lost him. I don't know, maybe some connectivity problems. But like, I would like to call Jemima to give the vote of thanks first. And then after that, I will invite our HOD, Mr. Kelly Malenia, to just say also thank you and explain to people what CLACLE is about. So Jemima, feel free to unmute and speak on behalf of CLACLE as our secretary. Yeah.
Thank you very much, Rugenge, for that. And thank you, each and every one of us, for being here today. I'm Jemima Mamati, the Secretary of CLACLE. And on behalf of Center for Legal Aid and Legal Education at Kabarak University Law School, I wish to extend our heartfelt gratitude to all those who have made today's inaugural webinar a resounding success. Well, first and foremost, our sincere appreciation goes to our distinguished panelists, that is Mr. Ian Duncan Ikisa, Mr. Cyrus Maweu, and Mr. Foluso Adegalu for your insightful contribution and for sharing your expertise on the implementation of the Ogiek case. I find that your perspectives have illuminated not only the legal dimensions of this landmark judgment, but it has also shown its profound implications for access to justice, that is, and indigenous rights and accountability in totality. And I'd like to thank our moderator, that is Rugenge, for guiding us throughout today's discussion with clarity and professionalism. And he has ensured that every voice was heard, and the dialogue remained engaging and thought-provoking. I would also love to extend our gratitude to our collaborators, that is the Network of African National Human Rights, NANHRI, for partnering with CLACLE in this important conversation. Together, we reaffirm the shared commitment in ensuring that human rights, its decisions move from a judgment to justice, from courtrooms to communities. And to our participants, we'd love to thank you for taking the time to join us and to ask insightful questions and enrich our collective understanding. And your engagement reminds us why such spaces like this are essential for nurturing a culture of justice and accountability. And finally, I would love to appreciate the CLACLE organizing team and the Kabarak University Law School administration for your hard work behind the scenes for making this possible. And as as we close, I would like us to carry forward the spirit of today's dialogue, that is to transform legal victories into lived realities for communities like the Ogiek and for all those whose rights are yet to be fully realized. I would also love to thank you all, and as we look forward to welcoming you in the next edition of the CLACLE webinar series, and I would love for you to have a wonderful afternoon. Thank you.
Thank you very much, Jemima, our secretary at CLACLE. Now allow me to invite our HOD, Head of Department, Mr. Kelly Malenya, just to tell us what is CLACLE and a few words in closing before we finish the webinar. Mr. Malenya, the floor is yours. You are muted.
Thank you very much, Rugenge. Can you hear me?
We can hear you now.
Yes, thank you very much for such a wonderful initiative, and to all our students for such a wonderful initiative. We also are grateful to the guests who was our speakers today. Of course, the main purpose of CLACLE is to train our students by doing, and we hope that with such initiatives, we are furthering our objectives and our mission. Thank you very much. I don't have very much because much has been said. I wish you a very good afternoon.
Thank you very much, Mr. Malenya. Asante sana. And thank you very much to all our panelists and the audience. I'll just ask you to stay tuned because the next edition of this webinar will come soon. So asante sana and all the best for the remaining time of your days. Yeah, bye-bye. So that will be the end.